All right, hi, welcome back, Attorney Steve Vondran. Welcome to another exciting video. Today we are talking about more intellectual property law with the ITC Section 337 proceeding. What are we talking about here? Well, without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so we are talking about the ITC, the U.S. International Trade Commission in Washington, D.C., where they're out here in Washington, D.C. This is what we call quasi-judicial. It's not actually like a court of law, but it's kind of like a court of law, quasi-judicial, okay? These are administrative proceedings under the Administrative Procedures Act. But I wanted to give you a quick overview of what it is in case you hear it. If you're an intellectual property rights holder, you may want to go to the ITC to have your infringement case heard, as opposed to going to federal court. Now, why would you want to do that? Well, number one, federal court is expensive. It's time consuming. It can drag on for years with an appeal and everything else. An ITC proceeding is designed to be quick. When I say quick, maybe within a year or so, okay? It's designed to be quick and determinative if somebody is infringing your intellectual property, such as your trademarks, your copyrights, your patents, your trade secrets, like the Colonel's secret recipe. That's a trade secret. Nobody knows what it is. A trade secret can last for the rest of the human existence as long as you keep it secret. So it's a really unique form of intellectual property, but those kinds of cases can also be heard. Most of them are going to, I think about 90% of your cases are considered to be patent infringement type cases. I was just reading a case before I started this about Easton baseball bats. I used to be a baseball player, so I was interested to see Easton baseball bats upset that other one or two or three other competitors were importing bats that were deemed to infringe their patent. And so the United States Customs and Border Protection, they're the ones that go through and make sure there's no counterfeit goods. We handle like Apple infringement cases where people are selling fake counterfeit iPads, earpads, all that kind of stuff, cables, lightning cables, those kinds of things. So the Customs and Border Protection will notify these companies when there's an infringement. But that's really done when they when a company goes through the e-recordation program, the e-recordation, and that is for your copyrights and your trademarks. And I always point this out under copyrights. I always think it's fun. Did you know a ship hull, the hull of a ship, can be copyrighted? I always throw that out there. I think one of these days I'm going to get a case involving a ship hull, and it's going to be some fun for me. But anyway, you can record your registered copyrights. You can record your federally registered trademarks, and the Border and Protection will enforce those. So if in other words, they open up a crate and they find something that says Apple on it, and it's not Apple, they'll notify Apple. Next thing you know, one of my clients will get a letter from Apple discussing intellectual property infringement. So that's kind of how it works in a nutshell, in case you didn't know. Now, basically, as I mentioned, you're going to file a complaint. It's an administrative procedure. Now, in these ITC proceedings, you cannot seek monetary damages. And that's probably why the case goes quicker. It's not about damages. It's about, is this company, is this defendant or respondent in a complaint, are they infringing your patent? Are they infringing your copyright? Are they infringing your trademark? And so those are the type of things you would allege. It's just like any other action. It proceeds with a complaint. The ITC has 30 days to decide if it wants to investigate or not. It does not have to. It can say, this doesn't look like there's a substantial pirating. It's not clear cut, and they can decide to say we do not want to initiate the proceeding and incur costs and all that. So. But they have 30 days to decide. If they say, yes, we're going to do it, they file what's called a notice of institution with the Federal Register. The Federal Register allows for public comments and things like that. So that happens, and then assuming that they go forward with the case, an administrative judge is appointed, administrative law judge, ALJ we call it. They set the discovery, a hearing date. There's also I wanted to point that out. There's an opportunity for mediation. So you could get a request for a Section 337 mediation, which is usually pretty nice. It gives you a chance to resolve your case cheaply and quickly. And sometimes if you have parties that are licensees and things like that, they may want to work together. They may have an interest in mediating the case. So that may be an option, a mediation within the 337 proceeding. But other than that, you have the respondent will file their response within, I believe it's 21 days. You have discovery. You have, just like a regular federal court case, you're going to have like a, let's say, 4 or 5 month, 6 month discovery procedure. Everything's going to be governed by the Administrative Procedures Act, which is similar to like the Federal Rules of Civil Procedure, FRCP. You have a trial, you have a decision within 90 days. The final decision can involve an exclusion order or a cease and desist order, but not damages. Again, you can't say, well, I want to get, $10 million in lost profits and attorney fees and all that. No, it's for an exclusion order, a cease and desist order. That goes to your U.S. Customs and Border Protection, which is bound under Section 337 of the Tariff Act. I believe it was 1930 Tariff Act, to follow these orders and to help the rights holder enforce their rights, copyright, trademarks, patent, trade secret, that kind of thing. So you could have this. I did notice, for example, I wanted to talk about parallel proceedings. I did notice in the Easton case, they were alleging 2 or 3 companies imported baseball bats. Easton is the big baseball bat company. It was way back in 30 years ago when I was playing college ball and all that. So, but you can have parallel proceedings. And in fact, I did see that they filed other federal court lawsuits against the defendants. So they were facing not only this ITC 337 proceeding, which would be good to try to quickly get this order to stop importing infringing goods, selling infringing goods, and things like that. So this allows you a quick way to get non-monetary damages, but you can also have a parallel proceeding. And also, like the Trademark and Trial and Appeal Board, the TTAB as we call it, you may have some action to try to, let's say, cancel a trademark or something like that, or take some other action against somebody. So that's the general overview of an ITC 333-7 proceeding. Again, designed to be quicker, no damages, but you could have these parallel proceedings. If you lose, there is a federal court appeal, so you can end up right back here in federal court anyway, but you may have this order in effect that you would have to deal with. So I hope that's helpful. That's a general legal information, not legal advice, general overview. I hope that helps. If you need help with intellectual property matters, trademarks, copyrights, you know where to find trade secrets. You know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I hope this has been helpful. If you like this, make sure you subscribe. That keeps me going. It motivates me. It allows you to get some great information, things you don't learn this stuff in business school or anything like that. This isn't something that really comes up. So this is your chance to learn about our legal system, our great legal system, and to learn more about intellectual property rights, enforcing, and sometimes you end up defending on the other side of these cases. So that's it. Hope you guys have a great weekend. Gotta run. Bye now.